we found out that Andy had been subpoenaed through two different methods, two different platforms. And then there was a TikTok that was like a copycat of his channel, and they got it too. And I think we think they thought that that was actually him. So it seemed like they did it from three different platforms. So we were thinking, so I just want to get to this real quick because Lauren's going to go live next and I'm going to join her. But we did this because we were afraid that this could be just for Google and she would find another way around it and catch us off guard, thinking that she could subpoena us another way. So we wanted to take care of that. And also, it was just wrong what she did. Okay. Thank you, Christina. Ready to block and put people on timeouts. Okay. So I want to go through this real quick so that I don't cross into Lauren. But I wanted to, since it's my filing, I wanted to be the first one to share it and go through it. Hey, just Ricardo, thank you. Hi, Cassidy. Hello, lovelies. I've been running around and doing chores all day. So I say, Dear Judge Lyman, I respectfully submit this letter pursuant to your honor's individual practices in civil cases. So if you don't remember what that is, each federal judge has his own what's called individual practices. That's kind of their specific rules for the court. How they want documents turned in, the format of them, all of that kind of stuff. The Federal Rules for Civil Procedure 26C, motion for a protective order and for sanctions against Miss Lively, Miss Lively's counsel Ezra Hudson, and her law firm Manat, Phelps, and Phillips for reasons detailed in this letter and accompanying motion. On July 3rd, 2025, counsel for Miss Lively, Ezra Hudson, improperly issued a single subpoena directed at 43, which we've now learned there are 107. So she used one subpoena to do all of this, which is outrageous. Many of which did not operate under their proper names, often referred to in these situations as anonymous Doe individuals. So if you followed for a while, you've seen where I've talked about like Doe lawsuits and then these kind of subpoenas against people on their social media accounts. And they would be referred to as Does because many people don't go by their real name on social media. And in order to get people's identifying information, there's a really strict procedure that you have to go through because you're talking about First Amendment rights. So the way that Blake has been allowed to just take this one subpoena and send it to all of these platforms against all of these people, it's insane. And it is not how this works in actual cases. Even in the Southern District of New York, I've quoted a specific case to that. Sorry, I'm out of breath. I was lugging in rubber mulch and stuff. So carrying that around. So I'm kind of out of breath. And then I found out that this hit and I was like, oh, I got to hurry. So at the time I thought it was only 43 because I filed this actually on Monday. These 43 separate and distinct individuals were not served separately, but from one sort of bulk subpoena, as if the court were a Costco. I had to say that because it's like she's got one subpoena and she wants to use it in all 107 places. It's insane. You can't do that. Why is he allowing this to happen? He must be a joke amongst his peers right now. I don't know if you guys saw my post, but somebody else was just doxxed in Blake's exhibits for this second amended complaint that she filed last night. So another doxing after all of this, it's still happening. He has completely lost control of everything in this court because he's letting all of these things happen. And I can't even imagine what other judges are thinking. Costco Cassidy. Yes. I had to say that. I'm like, it's like the court's a Costco. So this wholesale warehouse style subpoena is even more shocking because it was served on at least 3 separate and distinct social media platforms and was not served all at once, but rather over the course of several weeks, with different requests for each platform. So not only is this subpoena meant for all of these different people, but it's several different platforms in different jurisdictions, none of them New York, none of them within 100-mile radius of his courthouse, which is the only that's a limit to what they can subpoena from that court. So everything about this subpoena is just wrong. So it's all different jurisdictions, all different platforms, asking for different things, sent out at different times, all on this one Costco subpoena. The subpoena lacked the procedural clarity required by Federal Rules of Civil Procedure 45A1A. So and that just quotes it. But these subpoenas were not only procedurally defective, issued in bad faith, which is a clear abuse of process, which is why she could and should be sanctioned, but also constituted an attempt to harass, intimidate, and unmask anonymous speakers without court approval or any showing of relevance or necessity. So this subpoena, this magical bulk Costco subpoena that defies any jurisdiction, it fails for all of these reasons. Several recipients filed motions to quash, citing legal deficiencies under Rule 45, relevance, undue burden, and First Amendment concerns, which must be overcome before an anonymous user of the internet is allowed to be unmasked. So this is that case. This happened in the Southern District of New York. Sony Music Entertainment versus Doe's. And they were looking for people for copyright violations, which is actually against the law. But even in that situation, it had to go through the court first. They have to have a prima facie showing and get a court order to do this. But she's just been allowed to serve the subpoena here, there, and everywhere. Why is this being allowed? The second it was brought to his attention, he should have stopped it in that moment and asked her, on whose authority did you even issue this subpoena to all of these different jurisdictions? But there it is. And today's the last day. Today's the deadline, at least for the Google subpoena. I don't know if the others had later deadlines, but the Google subpoena, those motions to quash had to be filed today. And if anyone was doing it pro se, it's too late now. So it's absolutely insane that nobody has said on what authority was this magical Costco subpoena issued. Because that law right there, that case law right there says this subpoena is bad. So rather than respond substantively, counsel for Miss Lively strategically withdrew the subpoena after it became evident that the motion to quash filed by myself and other subpoenaed non-parties were meritorious. The timing strongly suggests that the withdrawal was designed to evade judicial scrutiny, review, and prevent an adverse ruling from appearing on the record. Courts have repeatedly criticized this type of conduct. So what this means is, so my motion to quash was filed first. So Ezra had till Monday to respond to my motion to quash. Well, in my motion to quash, I had rules like this that she could not have overcome legally. So instead of having to deal with that on Monday, on Saturday, she withdrew it. By withdrawing it, that means the judge doesn't have to look at it and make a ruling on it. So she avoided him looking at it and saying, hey, this subpoena doesn't stand up legally. So she got to keep using it. So anybody who fights it, she knows these rules and standards. She knows they won't stand up to scrutiny. So as soon as anybody says anything, she withdraws it. So the court doesn't get a chance to rule on it. This is abuse of process. This is not right. In addition to asking the court to withdraw the subpoena on behalf of those listed in docket 496, she dares to strategically request that the court deny the third party's motions to quash as moot. So that's what I was saying. She had the court deny it so she didn't have to deal with the ruling. Should the court indulge this request, it would be an excellent strategy indeed. For not only would it spare her judicial review of our motions to quash, but as a denial of our motion, it would also appear on the court record as a ruling in her favor, because our motions to quash become denied. So it's like she won that round. More importantly, it leaves her legally questionable subpoena intact to continue to wreak havoc on other content creators already named by it and any additional content creators. Miss Lively intends to use this buy one, get 59 free subpoena, because at that time we thought she had asked for only 60. So now she's got a buy one, get 106 free subpoena. That she informed the court she needed to extend the discovery schedule in order to continue plucking names to reuse it on, seemingly at whim, with no evidence or proper procedure behind it. So, what that means, no evidence, like I said, for this type of subpoena that goes to somewhere like Google or whatever, you have to show evidence. You have to have a showing before the judge. And you have to present a good case in order to get it. She didn't do any of that. And she still gets to keep using it because of this strategic withdrawal. As soon as anybody stands up against her, she withdraws it so that there's no ruling. So she can keep using the same subpoena over and over. Never in my life have I seen anything like this. This is crazy. In another strategic move, Miss Lively's counsel brings to her letter mentions of Mr. Fritz's latest filing with no relevance to move-in situation whatsoever. Remember, she had a whole paragraph and then a screenshot of something talking about the smear campaign. That had nothing to do with our motion to quash. Miss Lively to date has failed to inform the receivers, that's us, or sorry, my little mic thing swings. I need to get a little closer because it's kind of blurry. On what legal basis Movent and the other receivers' names were chosen to receive this questionable subpoena. She was caught in her lies to the public and to his honor, I'm talking about Ezra, when she reacted to docket 444 and 445 by stating that our names were chosen to be subpoenaed by Miss Lively because we were on a list provided by TAG in their interrogatories, and that the criticism being brought to Miss Lively because of the subpoena were unfair and of Wayfarer's doing. She lied again, stating that because of Wayfarer's counsel keeping the list improperly designated as attorney's eyes only, Miss Lively was being unfairly targeted and could not produce the list to defend her erroneous subpoena. So what that's about is mine and Leanne's motions to quash hit first, and that was 444 and 445. Or was it mine and Leanne's or mine and Lauren? Oh, Lauren's letter was 444, and then my motion to quash was 445. And that's when she freaked out and said, oh, their names are on this list because of it's TAG's fault. They were on TAG's interrogatories. Remember? She said that why we were chosen is because we were on this list from them. Tried to put all the blame to them. And we're saying, no, she lied to the court. She lied to the public. That wasn't true. On the contrary, Miss Lively's claims made us a target because her claims were believed by her supporters, who quickly targeted us, repeatedly quoting those lies and putting blemishes on our reputations. We were unable to defend ourselves against these lies because people put faith in legal documents filed in this court, as the public should be able to do. In this case, it was us, not this court's docket, that held the truth, and had Wayfarer not voluntarily stepped forward, stripped their attorney's eyes only designation, and revealed the list to the public, our reputations would still be in question. These circumstances make the second paragraph and image found on page 1 of docket 496, that's her fussing about Wayfarer, that had nothing to do with our motions to quash, especially distasteful after such treatment. She continues to try to put forth accusations on the very document meant to release us from this subpoena. In her continued lies to the public and to his honor, she begins a sentence with, based on the third party's representations made in meet and confers, leading you all to believe that she met and conferred with us. She did not. Although attempts were made to do so, Miss Hudson informed those she intended to meet with that there would be upwards of 4 attorneys included in a Zoom call. Outrageous, as none of these receivers were legally represented, and that they would not be allowed to record the meeting in any way or have anyone else present for it. None of the receivers felt safe to speak with her under those conditions. The intimidation was keenly felt. Miss Hudson's misrepresentations to the public and his honor continue when she states, there is no further information required from the subpoenas as to these specific third parties at this time. Making this statement after the statement that she had met and conferred with us leaves the implication that she in fact received information from these imaginary meet and confers, as she deceptively uses the words, no further information. It cannot be denied that in order for there to be further information, some information had to have been provided. Since these meet and confers did not take place, this simply could not have happened and did not happen. I wanted him to know she lied because he only knows what she files in court. Page 2 of docket 496 does not get any better, as it continues to imply there was a link between us and Wayfarer in this mythological smear campaign when she states, Miss Lively's subpoenas were one part of the discovery process aimed at gathering information to link the Wayfarer party's activities to sources through YouTube and X content creator accounts. And I think it's interesting, she says subpoenas, like she doesn't want the court to realize she's only using one over and over again, which is an extraordinary claim since there is absolutely no link between our channels and the Wayfarer parties. Instead of these insinuations, it would have been much more helpful for her to have supplied the court with the slightest hint as to why the names on this bulk subpoena were chosen, or even the tiniest drop of the legal reasoning behind it. But no, she simply requests the court to brush it away as if it never happened. The lie is repeated that Miss Lively's counsel has met and conferred with various individuals whose account information is the subject of the subpoenas, including the third parties who have filed motions to quash, when she well knows these meet and confers did not take place, and then asks the court to deny them as moot, something we object to for the reasons stated herein. In her footnote, she mentions movements asking the court to revoke the subpoena as a whole, because we were afraid that a lot of people never knew that they got this subpoena. And so we wanted to try to help everybody. So we said, this subpoena is not good for us. This subpoena is no good for anybody. And so she's trying to make sure that even though she withdrew it for us, that it got to stay intact. Yeah, so she states case law in her footnote and informs the court, movement, me, does not have the power to request this on behalf of anyone else. However, the reasons movement has stated and continues to state that make the subpoena invalid are not specific to a certain group of receivers. If the subpoena fails based on procedure, rules, and standards, it fails completely as a legal document and becomes invalid for all. This is the basis on which movement makes this request to the court. So I'm saying if this thing fails, it doesn't just fail for those of us who filed motions to quash. If it was an abusive process, if it was improperly gotten, it fails for everybody. So in the following motion, movement intends to request a protective order prohibiting plaintiff's counsel from attempting to reissue this abusive subpoena to me on any platform I'm on, or the issuance of any such subpoenas to anonymous or DOE individuals without prior court approval, as is procedurally proper with DOE-type subpoenas. 2. A formal finding by the court that the original subpoena was issued in bad faith and constituted abuse of process. 3. Sanctions in the form of punitive damages. Punitive damages are damages that are put on someone as like a punishment to stop that behavior so that someone doesn't do it again. Because we can't ask for attorney's fees. We didn't hire attorneys, but we want something done to stop this madness. To discourage plaintiff's counsel from victimizing others in the future, as movement has been. This motion to quash was filed pro se, and no attorney's fees were incurred. It did, however, take many hours of research and writing over many days and nights, interfering with time that could have been spent creating content, leading to a loss of income. The threats of unmasking, given my specific circumstances, brought a great deal of anxiety and stress over the real fear of being found and victimized again, reigniting PTSD from a long-term stalking situation that required an extensive period of treatment. This intrusive subpoena, issued outside of the legal standards, has led to a resumption of therapy, which I had been able to go a long time without after previous successful treatment. So guys, I'm going to go through the super chats at the end, but I want to say thank you now. But I'm so easily distracted and I'm trying to hurry. So I'll do it all at the end, but I don't want you to feel ignored. And I'm very, very grateful. And if you notice that little duck in the top right corner is gone, I was using free StreamYard for a long time, but I wanted to let you guys know because you guys were so generous when all this happened with your super chats. And I wanted to put it back into my channel. So I was able to buy StreamYard now. So I don't have that duck and I have some better features and things like that. So that's thanks to you guys. And I wanted to let you know what I did with the money. So here is the memorandum. It's a post-withdrawal motion because the subpoena's already been withdrawn. So normally, once it's withdrawn, there's nothing more that can be said about it. But with this type of document, it has an allowance for that based on specific circumstances, like abusive process. So a post-withdrawal motion for protective order and sanctions due to abusive process in bad faith issuance of subpoena and strategic withdrawal. So her withdrawal was strategic. It wasn't like, oh, okay, I'm just going to take it. It's like she took it off of only people who stood up to it so that it didn't get shut down by the court. And that's strategic withdrawal, and that's not a good move. So pursuant to Federal Rules of Civil Procedure 26C and the court's inherent authority to deter abuse of judicial process, movement appearing pro se respectfully moves the court for protective order barring further misuse of subpoena power and also sanctions, including punitive damages against Ms. Lively, her counsel, and counsel's law firm for improper issuance of a bad faith bulk subpoena and strategic withdrawal of subpoenas served on 43 content creators, which again we know is 107 now, many of which operate without their proper names, thereby DOEs, spanning 3 separate and distinct platforms on different dates, with some issued weeks apart, requesting different and distinct information and served via these social media platforms. Background. Beginning on July 3rd, 2025, Plaintiff's Counsel Ezra Hudson issued and attempted to serve one subpoena to cover over 40 mostly anonymous individuals via social media platforms, seeking broad and undefined categories of information. This subpoena amounted to a baseless fishing expedition as a last-ditch, desperate effort to find some scrap of evidence to support the alleged smear campaign that appears to only exist in plaintiff's imagination. After several recipients filed motions to quash detailing the subpoena's astonishing overbreadth, lack of relevance, procedural defects, and improper purpose, Plaintiff's counsel Ezra Hudson strategically withdrew the subpoena, specifying it was withdrawn only on behalf of those who had filed these motions, but should stay intact for all others. In an obvious attempt to block judicial review and any ruling the court would issue based upon the legal applications outlined in these motions to quash. In short, it's a continuation of plaintiff's counsel's abuse of the issuance and application of subpoena power that began long before this lawsuit. And we got to keep this part alive. We got to keep talking about this part. When counsel's law firm issued a sham subpoena on behalf of Miss Lively using a shell company that now names Miss Lively's husband, Ryan Reynolds, as CEO, which makes it even more of a mystery how such a company could file a lawsuit related to Wayfair parties. So it's even weirder. I don't know what they thought they were doing with Ryan becoming CEO, but it's even weirder with him there because he has really nothing to do with Wayfair. Issued a Doe-type subpoena under the guise of breach of contract to be served on up to 10 does, but was only served upon Stephanie Jones of Jonesworks, Jennifer Abel's former employer, and served only to capture from Miss Jones the contents of Miss Abel's phone that she had obtained under questionable circumstances that are now being investigated in this lawsuit. Miss Lively and her counsel made a mockery of the legal process, the court under which they secretly filed the Van Zandt sham lawsuit, and now attempt to do the same to this esteemed federal court. We really want to put that on blast and be like, they're making a mockery of justice. They're making a mockery of lawsuits. They made a mockery of the New York court where they filed the sham lawsuit, and they're trying to do the same here. It's interesting to note that when a similar situation regarding an out-of-jurisdiction subpoena was issued to Taylor Swift via a docket in its proper jurisdiction in D.C., because that's what's supposed to happen when a subpoena is served outside of a 100-mile radius. It's mandatory by federal law that it's taken care of in the proper jurisdiction. And that's why they didn't dare mess with Taylor because they knew she had top-of-the-line attorneys. So hers properly went to Washington, D.C. Plaintiff's counsel had plenty to say about it. Remember, they were throwing fits about this subpoena, even feeling the need to bring it to this court's docket, as well as making multiple statements to mainstream media. The court's quick and decisive action to strike a filing from its docket as irrelevant to any issue before this court, those were directly Judge Lyman's quotes about this stuff on his docket. He's like, this doesn't belong on my docket. Okay, so why is this stuff on your docket then, sir? This is California. This is much further from you than Washington, D.C. The court was so determined to keep filings regarding the out-of-district Taylor Swift subpoena from its docket, it saw fit to swiftly and sternly further strike an additional document from the docket sua sponte, or without a request being made by either party. So normally, if something's going to be struck from the docket, one side or the other has to request it of the court. But he didn't even wait for that. He did it sua sponte, which that's what it means, that he does it on his own, not being asked to do it. It's just the judge makes a ruling all on his own. That's how strongly he felt about getting this stuff off. He's like, you don't even have to ask me. I'm getting this stuff off with my own authority. And yet here, this 107 different people are being subpoenaed with one subpoena. It's insane. And that's all just fine. And those are all just flowing through like nothing. They talked about it at the hearing yesterday. 107, not a word from him about that. Not a question from him about that. Nothing. The withdrawal of this subpoena as it pertains to these 5 receivers occurred only after it became evident that the subpoena could not survive judicial scrutiny under Rule 45, First Amendment protections for anonymous speech, relevant case law and standards, specifically the Nixon standard. This conduct has created prejudice and harm, including chilling anonymous, protected expression, coercive impact on non-parties, and denial of judicial determination on the abusive use of process. So this is, they subpoenaed the social media platforms, but this is about abuse of process. Some people were, well, here's the thing, that was the first step. The first step is to find out who we are, get our information. They didn't want our bank information for no reason. They wanted that so that they could subpoena it later. They wanted our addresses and our phone numbers so that they could serve us with actual subpoenas. So they served the people who they could directly, but those of us that they couldn't, this is the first step in finding the information to subpoena us directly. Okay, the legal standard, part 2. A party may move for a protective order under Rule 26C to shield themselves or others from annoyance, embarrassment, oppression, or undue burden or expense. Courts have inherent authority to sanction litigation misconduct, including bad faith issuance of subpoenas and manipulation of procedure to avoid accountability. So that's what she did. She withdrew it, not as a whole, not the whole subpoena, withdrew just ours before the judge could rule. And that is manipulation of procedure to avoid accountability. So, and then I have this case here, Chambers versus NASCO. A quote from that: courts may fashion an appropriate sanction for conduct which abuses the judicial process. The Supreme Court confirmed that federal courts possess inherent authority to issue sanctions for conduct that abuses the judicial process, even when such conduct may not violate an explicit rule. This power includes imposing sanctions for bad faith misuse of discovery tools such as subpoenas, where a party engages in tactics that are coercive, oppressive, or designed to harass or obstruct. The court held, a court may assess attorney's fees when a party has acted in bad faith, vexatiously, wantonly, I love that word, or for oppressive reasons. And further, the inherent power of a court can be invoked even if procedural rules exist which sanction the same conduct, because these rules are not substitutes for the inherent power. This means a court may go beyond Rule 11, Rule 26, or Rule 45 and use its inherent authority to prevent abuse of process where a party misuses judicial tools to harass third parties, intimidate, or retaliate against opponents, which I feel like that was. They chose those of us with the biggest mouths. Let's see. Circumvent proper procedure, they totally did, or withdraw problematic filings to avoid court scrutiny. Oh, you complained about it? Okay, I'm going to withdraw it then, so the court doesn't have to look at it. That's exactly what happened. So the next case, in Reyes versus City of New York, and I tried to find as many in the Southern District as I could. So this is in his district. The Southern District of New York addressed the misuse of subpoenas as an improper litigation tactic. The court held that Rule 45 subpoenas may not be used to harass, intimidate, or pressure individuals, especially when there is no legitimate evidentiary purpose. She has no evidence at all to base subpoenaing us. Nothing. In Reyes, the court emphasized subpoenas issued for the purpose of intimidation or harassment or that seek irrelevant information are an abusive process. Further, Rule 45 was not intended as a vehicle for oppression or tactics that chill participation in judicial proceedings. The court strongly condemned the attempt to misuse discovery power and reminded litigants that Rule 45 must be used in good faith and with procedural propriety. Next case is East Point versus Maxim. The U.S. District Court for the District of Connecticut, and so even though this is not New York, it is included in the Second Circuit, so it is in the same circuit, held that issuing subpoenas without proper notice and overbroad in scope constitutes misuse of Rule 45 and may be grounds for sanctions under Rule 45d1. The court found that the subpoenas were not issued to obtain admissible evidence, but were instead a means of harassment and a litigation tactic. The court stated, serving a subpoena without notice and for an improper purpose is sanctionable under Rule 45d1. The court also reaffirmed that the subpoena power is not a license to intimidate or to obtain irrelevant or confidential information like my bank account. And I have two, and one is linked to one family member and the other is linked to another. That's none of their business. Let's see. For strategic leverage, the court granted sanctions and emphasized that litigants who weaponize Rule 45 to pressure or punish individuals, particularly when the discovery sought is overbroad, irrelevant, or served without procedural compliance, they had no court order for, and which is required for this type of subpoena. And I don't know why more attorneys aren't talking about that. It's right there in the law. Look up that Sony case. Please, more attorneys, address this. Violate both the spirit and the letter of federal rules. B, it is well established that subpoenas issued under Rule 45 must be directed to a single individual or entity. Courts have routinely held that the aggregation of multiple recipients under one subpoena, like she did, especially when unnamed or anonymous, renders the subpoena unenforceable. Your Costco subpoena is no good. Your buy one, get 106 free subpoena is no good. In regards subpoena to Cisco Systems, this is a California one, but that's what I could find. You can't always find from the right district. The court struck a subpoena that named multiple parties and failed to comply with specificity and professional service rules, stating, each subpoena must be individually addressed and cannot aggregate multiple individuals or entities. Rule 45 does not permit generalized discovery instruments. How is this happening? 2. Malibu Media versus Doe's 1-10. A subpoena may only be issued to a specific identified recipient and must meet procedural requirements. It is improper to issue a single subpoena to compel information on multiple third parties. This is especially relevant in Doe unmasking cases, which is what this is. Groupon. Exactly. She got a Groupon for this subpoena, and it's not right. Rule 45 does not permit generalized discovery instruments because each of these Doe type subpoenas that are unmasking someone, for every single person involved in these 107 people, there would have to be an individual prima facie showing for every last one of them. And no court is going to put up with that. And then a new subpoena for each person. Okay, Mann versus University of Cincinnati. It is axiomatic that a subpoena must be directed at a specific individual or entity. Otherwise, enforcement would be impossible and the process compromised. This case is widely cited in procedural abuse cases. Part 3, argument. The subpoena was issued in bad faith. The record supports the inference that the subpoena was 1, overbroad, lacking specificity, and invasive. 2, issued outside this court's jurisdiction. 3, directed at anonymous non-parties without court leave, which means court permission. 4, lacked sound legal basis for issuance. Based on what evidence? None. 5, served via improper channels. also without court leave. It was served through social media. 6, over 40 content creators, now we know that's over 100, were served from one bulk Groupon subpoena with different dates, requests, and on different platforms. B, the subpoena was issued as a fishing expedition. This violates Rule 45D and more broadly, the Nixon standard. Now, this is a Supreme Court decision. Lower courts must abide by higher courts' decisions like this. This is a United States Supreme Court standard where the Supreme Court set forth the foundational standard governing the issuance and enforcement of subpoenas, particularly those seeking documents or testimony from third parties. Though the Nixon case involved a criminal subpoena, courts across circuits have consistently applied it to civil cases, outlining an impermissible fishing expedition or undue burden. The court held that the subpoena must be 1, relevant, 2, admissible, and 3, specific. The application must be made in good faith and not intended as a general fishing expedition. This 3-part test demands that the party issuing the subpoena demonstrate. This is straight from the Supreme Court. 1, the materials sought are evidentiary and relevant to the case. 2, that the evidence is not otherwise procurable through less burdensome means. You have a whole opposing party over there that you can get this information from. You didn't need to do this, Ezra, with an S. 3, that the subpoena describes the evidence with sufficient specificity to avoid imposing an undue burden or producing irrelevant material. My location from the time I started my channel, it's not your business. It's irrelevant information. My bank account is irrelevant information. Okay, let's see, where are we? Courts routinely apply the Nixon standard to Civil Rule 45 subpoenas to prevent misuse of the discovery process, including when subpoenas are overly broad or vague, not tailored to any specific claim or defense, used to intimidate or unmask anonymous parties, or issued in bad faith without a legitimate evidentiary goal. Federal courts, including those within the Second Circuit, have confirmed that Nixon standards are not limited to criminal cases. For example, in re-subpoena to Loeb and Loeb, the court must enforce the Nixon standard against overly broad civil subpoenas. Relevance, specificity, and necessity remain threshold requirements. Where's this court? Southern District of New York, sir. When you were being sworn in as a judge in 2019, or attempting to become a judge in 2019. Concord Boat Corps versus Brunswick. Subpoenas that fail to specify the subject matter with precision violate both Rule 45 and the standards of Nixon. Which court decided that? The Southern District of New York. Anwar versus Fairfield, Greenwich Limited. Rule 45 subpoenas must be narrowly tailored. They must avoid undue burden and conform to the standard articulated in the United States versus Nixon. It's a Supreme Court ruling in the Southern District of New York. Okay, thus, courts have not only upheld Nixon as binding precedent on discovery scope, but also emphasized that a party's failure to meet all 3 prongs renders a subpoena facially invalid and subject to quashing or sanctions, how about both, under Rule 45D. C, in this case, the subpoena at issue fails every element of the Nixon test. 1, it is not specific. It is directed at, correction, 107 individuals, most of which are known by platform pseudonyms, without tailored requests. 2, it is not shown to be relevant. No factual nexus or evidentiary purpose is articulated. 3, it was issued as part of an apparent fishing expedition and strategically withdrawn when challenged. Accordingly, sorry, I need a drink again. Accordingly, under United States versus Nixon, and consistent with Rule 45D3A, the subpoena should be declared an abuse of process and a protective order granted to prohibit further improper issuance. Not just me, not just those of us who've responded, everyone. D, strategic withdrawal shows conscious and deliberate avoidance of accountability. Opposing counsel did not withdraw the subpoena until facing detailed legal objections, and still has not withdrawn it from the remaining subjects it was issued to who have not yet filed motions to quash, either out of fear, lack of knowledge or ability of how to do so, or possibly have not yet discovered the subpoena due to notice going to spam or having lost access to an old email. This strategic withdrawal, 1, avoids adverse judicial precedent. 2, prevents a court order that might restrict future conduct. 3, evades responsibility for the intimidation and burden already inflicted. Courts have sanctioned parties for this tactic, recognizing it as manipulative and obstructive of judicial function. 4, relief quested. Movement respectfully requests that the court, 1, enter a protective order barring a reissue of this subpoena upon movement on any platform, and to bar any further subpoenas to anonymous or non-party individuals without court leave, which is the way it's supposed to be done in the first place. 2, award punitive damages as a sanction for abuse of process. 3, enter a formal finding on the record that the subpoena was withdrawn in the face of meritorious legal challenges to protect the record from manipulation. And 4, grant any other relief the court deems just and proper. So it's our wish that at least with this, it's not as simple as just withdrawing the subpoena. Hopefully this is something the court must address and at least read, and hopefully save some of these other people. I'm not going to stay on long because I know Lauren's going to go live. I just wanted, I was really proud of this one, and I wanted to be the first to share it. And I told you guys that when it hit the docket that I would share it. So I just want to say, Just Ricardo, thank you so much. And Just Ricardo Part 2, Ezra don't understand. The internet is forever. Yeah, that's why I said I hope she's getting paid retirement money here, because this could mess up her career a little bit. Of course, I don't know. People are always looking for attorneys that don't mind allegedly abusing process like this mess. Justin Smotherman, thank you. Spoiler alert, she's going to reference Without a Crystal Ball and Flaw. Who is M and C? In a vague way as what she was referring to. I don't understand this one. I don't know who M and C is, or who she. Do you mean Ezra? And Silver Girl, thank you. Oh, and Justin, thank you. If I forgot to say thank you. Thank you very much, all of you. Thank you all for, oh, Jane too. I hope this helps you. Thank you, Jane. All right. Thank you guys so much for joining. I want to hurry up and get off to get over to Lauren's. And I feel excited. I feel really happy that I filed this on Monday morning, very early. So, reference the meet and confers. She's going to reference those meet and confers. Oh, the ones with the others? Yeah, but the thing about on our where she withdrew from ours, it was just about us 5. And it none of us met with her. So even if she tries to say she did have meet and confers, those people weren't a part of our motion to dismiss. Those people had attorneys. Theirs was completely separate. So there were no meet and confers for the people she was addressing in that motion. Anyway, have a great night, guys. I'll see you over at Lauren's if you're headed over there. And if you don't know who Lauren is, where have you been? It's the Court of Random Opinion. So meet me over there. Thank you guys so much for joining. Have a good night.